Vinay Shraff, advocate from Calcutta High Court. Those who have been connected with Beyond Law CLC would know that he has done several sessions with us, and he's also otherwise a chartered accountant. Therefore, taking cue from his knowledge and his background, we thought, why not understand? Because we have been seeing the issues in respect of the Income Tax Act. Therefore, we had requested him to explain the nuances of burden of proof under Section 68 of the Income Tax Act 1961, so that as a professional as well as a common man, we can understand the bird eye view in respect of that, so that you can further examine and develop the aspects as a professional or a person in case any such notice is issued. I will not take much time, and I will request Mr. Vinay to take over the session.
Thank you very much, sir, for inviting me and giving me this opportunity. I'm really delighted to be back with the Beyond Law CLC and Vikasji to deliberate upon the importance of the burden of proof with respect to Section 68 to Section 69D. So as we all know, Section 68 to 69 capital D belongs to the same set of family of the provision. They are almost analogous to each other. The difference being that when I come to the each sections, then I will explain the nuances and the difference between each section. But by and large, they are all presumptive sections. So they create some presumption in favor of the revenue. Now there is a difference between legal fiction and presumption. Usually there are some provision where a legal fiction is created by law, and once that legal fiction is created deeming something to be something else, then even if whether it is true or false, it does not matter. Then you cannot dispute that legal presumption until unless that provision itself is challenged, that the legal presumption which is there in the law is arbitrary or unreasonable, or it violates any of or any other articles of the Constitution of India. For example, a provision relating to legal fiction which immediately comes to my mind is Section 50 capital C. Now in Section 50C, there is a legal fiction that if your stamp duty value while buying or selling a property, immovable property, is more than the value of consideration which you have received, then the stamp duty value will replace the actual value of the consideration. Now, this is a legal fiction. So you have no opportunity to explain that, look, this stamp duty value is not the real value, and therefore it cannot be replaced with the actual consideration. But Section 68 to 69D are slightly different, where there is a legal presumption, but this legal presumption is a rebuttable presumption, and one may, and the law, even the section also permits that, to rebut that presumption by furnishing the necessary evidence. Now, what is 68 to 69D? In order to understand that, let us try to understand the purpose and objective of insertion of these provisions in the Income Tax Act in the first place. Now, the necessity for bringing into force this provision was that many assessees who had black money means a money which is essentially lying in cash, or suppose in a bank account which is not disclosed or known to the income tax department, or bank account is opened or the money or the property is lying in such a territory which is outside the purview of the Indian jurisdiction. For example, you see somebody has money lying in the Swiss bank account or any such tax haven, or any property is there, or somebody has amassed huge amount of cash by undertaking transaction outside the regular books of accounts and not paying income tax. Now, what these people do? How do they bring it into the economy? Because ultimately, if you see the cash is lying, then there is a limited use of the cash. One can use cash only to an extent, but there are several expenditures which cannot be done in cash. If suppose you are dealing with any big corporates or even small corporates, people don't accept cash, and it has been the same situation since time immemorial. So in order to bring that cash or unaccounted money or a black money into the system, there are accommodation entry provider. Now, what is this accommodation entry, which is also known as Jama Kharch in this commercial or the business world? What this accommodation entry provider or Jama Kharch entry provider does is that they accept cash from you. Now, in order to convert this cash into a legal money or white money, they will deposit it in some account. It may be an account of a private limited company or an individual or a partnership firm or any such entity. Now, through that, after deposit of that cash, the money comes back to the person who has given the cash, either in form of a loan or gift, or if it is a company, then in form of the share application. Now, in lieu of this conversion, this accommodation entry provider charges an upfront commission. And once you see, and so what this person who accepts this kind of a money will do, he will say that, look, I have received this money. He will give a bank statement of the person who has given him the money. He will try to establish that I have either received loan or gift or say share application, and therefore the assessing officer should treat it as the transaction as it is accounted for in my books of accounts. But the Income Tax Act, section 68 to 69D, goes beyond what is apparent to discover what is real. And if a satisfactory explanation, for example, let us start with section 68. It says that if any sum of money is credited in the books of accounts of an assessee, and he offers no explanation about the nature and source thereof, or the explanation offered by him is not satisfactory, then the amount which is credited in his book of accounts, so now that money which is credited in his books of accounts is not in form of the income, it is say either in form of a gift or in form of a loan or in form of a share capital. But the assessing officer has the power to presume such credit either in form of gift, loan or share capital as income. So the officer goes beyond what is apparent to discover what is the real transaction, and he says that this entry is a fictional entry, the transaction is a sham transaction, and this is nothing but your income, and therefore I will tax you. Similarly, there is section 69, which says that if there is any investment made by you but it is not recorded in your books of accounts, and you are not able to explain the nature and source of that investment, then also that addition can be made. Then comes section 69A. This is also very vital. It says that where you are found to be the owner of any money, bullion, jewelry, or other valuable article, and which is not recorded in your books of account, and you are not able to offer explanation about the nature and source of the acquisition of money, bullion, jewelry, or other valuable article, or your explanation is not satisfactory in the opinion of the officer, then such money or the value of the bullion or the jewelry shall be deemed to be the income of the assessee in the year in which it is discovered. So the addition will be made in the year in which such discovery is made, irrespective of the fact when such jewelry came into your possession, when you earned it. So the law of limitation does not apply if any discovery is made from your premises. So this provision, section 69A, is reflecting the rule of evidence as codified in section 110 of the Evidence Act, where you are found to be in possession of something, then you are deemed to be the owner. So even though you see the terminology used in section 69A is that if you are found to be the owner of any money, bullion, jewelry, or any other article, then the income will be taxed in your hand. But the reality is that if any such thing, money or jewelry or any bullion or any valuable article is found in your possession, then you will be deemed to be the owner as per section 110 of the Evidence Act. And the onus is upon you, or the burden of proof is upon you to explain that you are not the owner. So if you are able to demonstrate by virtue of a satisfactory explanation, maybe say a jewelry is found in your possession, and you are able to demonstrate that this jewelry is your ancestral jewelry. It came to you through generation to generation. Now you may be able to prove that through maybe say any family settlement or any gift deed given by your say parents to you, or maybe in form of a say probate of a will, or any say succession certificate. So you must be able to demonstrate that this jewelry has not come to you. It is not earned. It is not your income, even though you are the owner. But the explanation offered to you about the source of acquisition is satisfactory. So if that is satisfactory, no addition can be made to you. It is very important to understand here that it talks about the ownership. So suppose if you are able to demonstrate that the ownership of the property, that unexplained article or money or the jewelry came to you prior to the period of limitation as per section 149, then also the addition cannot be made to your account. Because suppose you bought some jewelry or say gold biscuit or something, say maybe 20 years back, and you are able to give a proof of that. So even though suppose you did not pay the income tax at that point of time, 20 years back, but now since it will fall outside the purview of section 149, so it cannot be added to your account. Or if you are able to demonstrate that you are not the owner, then also the addition cannot be made to your account. So after section 69A, there is section 69B, wherein investment is found and partly it is recorded in your books of account. But what is recorded in your books of accounts, the value of the investment exceeds much beyond that. Then also to the extent it is in excess and you are not able to give any proper explanation, the addition will be made. Then there is section 69C. So section 69C talks about the unexplained expenditure. If you have incurred any expenditure and you are not able to explain the source of such expenditure, then also such the addition can be made to you in your accounts. For example, you undertake a foreign travel, or suppose you go to fancy restaurants, or you incur huge amount of expenditure on the occasion of marriage of any of your family member, but you do not have any explanation about the source of such expenditure, then the addition can be made to your account. And then the last provision, section 69D, is amount borrowed or repaid on a hundi. So there also, if you are not able to explain as to the source thereof, then also the addition can be made to your account. So this is about the provision, this deeming provision. Now about what is your burden? Burden means burden essentially means that your obligation or the liability. So it is your statutory obligation. And the proof is the compendium of factual evidences to disprove something, to disprove the allegation made against you. So if any allegation is made with respect to the unexplained expenditure and the burden of proof is upon you, then you can give a satisfactory explanation and discharge your burden. And once that burden is discharged, then the onus shifts to the assessing officer to disprove your explanation. So now the question arises that how do you discharge your onus or the burden of proof? Now, in order to discharge the burden of proof, so what I'm saying is on the basis of the, well-established principle, which has evolved over a period of time through various judicial precedents. So I'm not going to refer to those judicial precedents, but to explain you as to how do you discharge your burden of proofs in this kind of a situation, there are three things you must prove. One is that you have to prove the identity of the creditor. Second is you have to prove the capacity of the creditor to advance you the money, whether in form of loan, gift, or share application money. And third is you have to establish the genuineness of the transaction. And then how do you do that? First is the identity of the creditor. Now, if your creditor who has lended you the money is a individual, then you can explain the identity through furnishing of the Aadhaar card, passport, PAN card, or the assessment orders which has been done. You can also request the officer to summon the concerned person under section 131 of the Income Tax Act and seek explanation from him. You can furnish his ITR and all that. Now, if it is a corporate lender, then also you can furnish PAN, certificate of incorporation, memorandum and article of association, various forms, annual return, etc., submitted to ROC or MCA from time to time. Then bank statement, PAN card, assessment order, if any. And through this, you submit the identity. And if it is a, non-resident lender, then you have to explain his identity through passport, certificate of residency, tax assessment order passed by the authorities of the country of residence, citizenship identification number. If it is the person concerned to be overseas, OCI card holder, then such a certificate. So through all these documents, you try to first of all establish, the first part is to establish the identity. Now the second is the credit worthiness. Now you may be able to prove that the transaction took through bank. You are also able to furnish the necessary identity, but you also have to prove that the person concerned who has lended you the money was enough resourceful. That means he was capable to lend you the money. Now this his capability you demonstrate through a statement of his assets and liabilities, which shows his adequate net worth. Bank statement showing adequate balance in his bank account before lending you. It should not be that you see 1 crore came to your account and just prior to that there is a credit from somewhere in his account. Now what happens is that many people who does this kind of you see accommodation entries, they deposit cash 3 or 4 level below, not in the same account from which the money is flowing to you. So maybe the balance, the usual balance in that account is say maybe not more than say 1,000, 2,000 rupees or 10,000 rupees. But suddenly 1 crore credit comes in that account and that money itself is lended to you. So that can be a reasonable, you see, cause for the assessing officer to presume that your explanation about the credit worthiness of the lender is not good enough. Now that lender may be in a position to explain it also, that why that money came, from which source he came, and if that is done, then that explanation has to be considered by the officer. But I am talking of the first level for the time being. I will come to the source of source in the later part of my discussion. Whether the source of source also needs to be explained, that aspect I will discuss later on. Now, the last aspect is the genuineness of the transaction. Now, the genuineness of the transaction is explained that suppose what happens in a normal scenario, that if somebody is lending you the money, then he will look for sufficient security through mortgage of some property. So that security arrangement you can show. Then you can also show that you are regularly paying interest at the market rate. And from time to time, as per schedule, you are returning the money. And there is a timely and proper response by the lender to demonstrate the genuineness of the transaction, his capacity to lend, his credit worthiness, and everything. Whenever any notice is issued to that lender, he should present himself and demonstrate everything apart from the documentary evidence which you furnish. Now, it is not necessary that you have done all that you could have done by furnishing the necessary evidences. But the concerned person who is called under section 131, he does not respond. Now, that is not a reason enough to make an addition to your account. But in case where it is doubtful, on the basis of the documents which you have submitted, then obviously the addition can be made to your account. Now, after doing all these things, after furnishing or discharging the initial burden with respect to all the three aspects, now the assessing officer cannot sit with folded hands and say, on the basis of presumption and assumption, without making any further inquiry, that your explanation is not satisfactory, so I am making the addition. So once the initial onus is discharged by the assessee, Then the owner shifts to the revenue to scrutinize the material and then do further investigation and then come to a conclusion. For example, if the SAC is requesting that so and so witness needs to be summoned under section 131 to enable him to discharge his honors, then the officer is bound to exercise his power under 131. He cannot say, no, I will not call that witness into question. It is not upon me. That is not how the law operates. So it is not that once the initial burden is discharged by the SAC, the revenue can discard the material furnished by you on some flimsy ground without doing further investigation. Or, for example, if in order to discharge your honors, you need some assistance of the department because there are certain things which is beyond your purview, then the department is bound to accede to your request. You see, there are judgments of the Supreme Court which says that the government should be a ideal litigant. They cannot act like other litigants where you see they shift the burden of proof or the onus on the SAC, and on such technical pleas, they don't assist the citizen. So by hook or by crook, it is not that just because the burden is upon me, so by hook or by crook, the addition will be made. So whatever comes, evidence is gathered by the department against me, that should be considered to be sacrosanct. And if I am asking the department to do some further investigation to help me to unearth the fact, the department will discard such a request from my end. Now, another aspect here is that the books of accounts. What is the meaning of the books of accounts? Because it talks about section 68, section 69 or 69B and 69 talks about the books of accounts. So what is the meaning of the books of accounts? Books of accounts, which has been defined in section 2, subsection 12A, means ledger, day books, cash books, account books, or other books which are kept in the written form or in the electronic form or in the digital form or as printout of the data stored in such digital form in a floppy disk, tape, or any other electromagnetic data storage device. Now, this issue of what is a books of accounts was also discussed in one celebrated judgment, CBI versus VC Shukla, reported in AIR 1998, Supreme Court, page 1406. Now here, this judgment is a case, if you will recall, it is a judgment with respect to entries in the Jain Hawala diaries and the loose notebooks and file containing loose sheet of papers. Now, the Honorable Supreme Court held that such loose entries in the loose sheets and papers are not admissible under Section 34 of the Evidence Act, as they are not regularly kept books of accounts. So, books of accounts can only be if they are a regularly kept books of accounts, where the entries are made on a day-to-day basis and it is in a bound form. If some entry is in some coded word is made on a loose sheet of material and it is discovered by the investigating officer in case of a search or seizure operation, that cannot be considered as a books of accounts or a book. So this section 68, the family of section 68 to 69D operates with respect to proper books of accounts. So addition can be made under these sections only if there is any entry in the books of accounts. Now, any entry in this loose sheets of paper, since they cannot be considered to be books of accounts, no addition can be made under these sections at least. It may be that if any such entry is found, any loose sheet of paper, that it may give rise to the suspicion that there is some evasion which has taken place, and the concerned officer may do further investigation and unearth the truth by bringing into record some corroborative evidence to demonstrate that there is some escapement of income. But you see, the burden, whenever you see any allegation is made by the department on the basis of any such loose entry, then the burden is on the department. So in those kind of scenario, the burden is not on the SAC. First of all, the burden is on the department to bring some material on the basis of which they can say that it is my income. Merely because they have discovered some loose sheets and all that, they cannot straight away make an addition and then shift the burden upon me. If they have discovered some material which gives rise to the suspicion, then the officer concerned is duty bound to gather some evidence to make an allegation that there is a evasion of tax and then seek explanation from me. Merely on the basis of conjectures and surmises, no addition can be made. Now, secondly, these books of accounts refer to my books of accounts. So suppose there is any entry, somebody is saying that he has lended me money, but there is no corresponding entry in my books of accounts. Then the onus is not upon me to explain somebody else's books of accounts. The onus is upon that person to explain his part of his side of the story. Somebody just by making entry in his books of account cannot shift the burden to somebody else. So this is also very, very important. Now, with respect to discharge of the burden of proof and the shifting of the burden, I refer to two case studies or the real time, reference from the real time judgments. In one case, the burden was considered to be discharged, and in another case, it was not. So the first case is where a gift was received by someone from a close relative who was a resident outside India. Now he furnished the bank statement and all the evidence which he could, including a confirmation letter from the non-resident that he has lended him money or he has gifted him money. He also informed the assessing officer in writing that the donor was available in India due to the demise of his mother-in-law and is available for any inquiry, and also furnished the donor's complete address and mobile number. But the assessing officer made addition by saying that the explanation offered by the assessee was not satisfactory, and consequently he said that the identity or the credit worthiness or the genuineness of the transaction could not be verified, and made addition under section 68. The SSE took the matter in appeal and further before the tribunal. The tribunal reversed the order of the lower authority by holding that the genuineness of the gift were not proved is not correct. The assessing officer has made the addition on the basis of conjecture and surmises, and he failed to take any step to examine the donor or to make any independent inquiry with regard to the gift, and therefore section 68 was not invocable. Also on the basis that the entries were there only in the bank passbook and they are not regular books of accounts. Now, whether that bank passbook is a regular books of accounts is a matter of dispute. Some courts have held that bank passbook is not a books of accounts. So therefore, no addition can be made under 68. But some courts have said that, look, by not entering anything which is there in your own passbook, you cannot take advantage of your own wrong. So there are both, you see, aspect of the same side. And the matter has not yet been decided by the Supreme Court about this particular aspect, at least. And the High Court confirmed the order of the tribunal. Now, there is another case where you see somebody received gift from their own parents. Now, when he was asked to explain, then she said that my parents received it by through lease of the ancestral land belonging to them. But when the assessing officer asked him to furnish any proof, she was not in a position to furnish any proof with respect to the ownership of the land or that they were having any inherited property. So the High Court ultimately held that the assessee did not discharge his burden as he could not establish the credit worthiness of the creditor, and therefore the addition made is justified. Now, the another aspect is the source of source conundrum. Now, under section 68, there are two amendments, one in 2012, other in 2022. In 2012, you see, prior to 2012, whether with respect to loan or whether with respect to share application money, the consistent stand of all the courts and the Supreme Court was that you are only liable to explain the source. So you establish the credit worthiness of your lender, you establish the identity, and you establish the genuineness of the transaction. But you need not go beyond that. The officer concerned cannot ask you to further go one level below and establish your credit worthiness. Worthiness of the lender. But now this was amended by by Finance Act 2012 with effect from 1/4/2013, whereby if you are a company which is a private limited company, not a public limited company, any share application money or share capital or share premium is received by you, then the person who has invested in your company is also liable to explain the credit in his books of accounts. So now not only source is required to be explained, but source of source is also required to be explained with respect to share application money with effect from 1/4/2013. So now this is again a double deeming provision. So you explain not only the source, but the source of source also. Similar amendment was made by Finance Act 2022 with effect from 1/4/23, wherein if any loan is taken or any borrowing is done by you, then it is not enough that you explain the identity, credit worthiness, or the genuineness of the transaction of your lender. You also need to do the explain the credit in the books of accounts of your lender. So the source from which the money came into the account of your lender and his credit worthiness, that also needs to be explained. So the source of source is a amendment with respect to share application with effect from 1/4/2012, 13 with respect to loan 1/4/2023, And we also need to explain source of source now. Now, the another question which comes to mind is whether these amendments are prospective or retrospective. Now, in my opinion, these amendments are substantial amendment, and we all know from the judgment of VKC Township, VK Township rather, that if any amendment is clarificatory, only then it is retrospective, otherwise it is prospective. So in my view, all these amendments, since they are substantial amendment, so they cannot be said to be retrospective. Only with effect from the date that these amendments came into force, these amendments will apply. Secondly, one may say that it may be impossible from me, it is beyond my means to explain the source of the source. So in my view, one can also test this particular provision, the validity part of it, for the courts to test whether they satisfy Article 14, because it has been consistent stand of the Honorable Supreme Court that you cannot ask me to do the impossible. And if something or something which is arbitrary or unreasonable. So the question is whether this kind of a provision, whether I am asked to explain the source of source, is arbitrary or unreasonable, or manifestly arbitrary or unreasonable, and therefore it needs to be read down or not. So this is something which probably will be tested by the courts in the time to come. Uh, so I think I've covered all the aspects by now. Let me just go through my notes. Okay. So just to, before I conclude, I would like to summarize today's discussion that under this section 68 to 69D, an addition can be made where there is no satisfactory explanation about the money in your credited in your books of accounts, or money which is there with you but not accounted for in the books of accounts. So either it is found in form of a cash which is unaccounted, or something which is accounted but there is no proper explanation about the nature and source thereof. So by virtue of these deeming provisions, an addition can be made to you, but you can discharge the burden of proof upon you by furnishing the identity, creditworthiness, and genuineness of the transaction. And once you discharge the initial burden, then the burden shifts to the assessing officer, and he is bound to take into account your explanation, do necessary inquiry, help you to discharge your burden. He cannot throw his own hand in the air and say that I will make addition on the basis of whatever you have made me available, or whatever is there with me. I will not do any further investigation. That cannot be the attitude of the officer. Once you have discharged your initial burden, then the burden shifts to the assessing officer and is bound to do the necessary inquiry and come to a proper conclusion. So, friends, with this, I conclude my today's session. If there are any queries, then I'll be happy to discuss further. Or if any participants want to contradict me, or to come up with any new aspect or facet of the discussion which we are doing now, then I'll be very happy to engage in any conversation or discussion, or if you want to make a point, you can do so. Thank you very much.
I'm just checking out as to whether we have any query. No, I think you have elaborately explained, and last week also you did one of the sessions on this. Probably that's why there's no question. Thank you, Mr. Vinay, for sharing your knowledge. And we are thank you, and we will stay connected for more series on this. Thank you.
Thank you very much, sir. Thank you.
Thank you.
My pleasure.